The vetting of all judges and magistrates serving at the time of the enactment of the new constitution in 2010 was at the heart of far-reaching reforms targeted at key institutions, the judiciary among them. But the verdict of a 5-judge High Court bench blocking the sacking of 5 judges declared unfit to hold public office by the Vetting of Judges and Magistrates Board has triggered a series of questions, among them what the framers of the Constitution envisaged in the vetting exercise and whether the High Court was in order to block the sacking of the judges declared unfit to hold office by the vetting board.
So the intention was insulate this process from the ordinary court because there is still a lot of institutional reform going on, and which is why it was put in the transitional provisions, because it is one of those sections of the Constitution that are supposed to bring into effect the current Constitution. That was the intention. Protect it, but maintain the principle of vetting so that any judge who is now found to be suitable can walk shoulder high and say, I'm indeed an authority, a judicial authority.
So the idea was to ensure that this was a process that would receive finality with its own pronouncements, and also would be insulated from the encumbrances that we are seeing right now of people going to court, various parties going to court and delaying the outcome of the process.
The officials who drafted the Constitution cite Article 23(2) of the Constitution that insulates the operations and decisions of the Vetting of Judges and Magistrates Board from any interference by the courts. The High Court's ruling Tuesday raising pertinent questions from the 2 members of the defunct Committee of Experts.
If you look at the language in Section 23(2), which talks about any court, maybe what we should be asking ourselves, is High Court any court? Is the Supreme Court any court? Is the Magistrates Court any court? Is the Catholic Court any court? Is a tribunal any court? I think that is the verdict that should be out there to the people of Kenya. It is their constitution. This is what they said. And as framers of the Constitution, we put exactly what the intention of Kenyans were. And that's precisely the language of Section 23(2).
The decision of the board to state that certain individuals or certain parties are unsuitable after the process, then it would mean that those persons or those individuals would cease to hold office. And the constitutional legal way of now ensuring that officially they are not recognized as office holders is through the degazettement, which unfortunately was not forthcoming after the decision of the board 2 months ago.
Dr. Ekuru Aukot disclosed that the vetting of judges was a compromise struck between the Committee of Experts and the Kenya Judges and Magistrates Association in 2010, and that the situation could have been drastic if a proposal contained in the harmonized draft constitution published by the CoE in 2009 was upheld.
We had a meeting with them after the harmonized draft constitution came out, because the harmonized draft constitution provisions were very drastic and harsh. It was actually sack all judges and magistrates, let them apply afresh. But as the Committee of Experts, we reasoned, we say, no, we cannot do that because that is very drastic. I know many Kenyans were very angry, and some even criticized the Committee of Experts. So really the vetting and the insulation was a compromise.
But the aggrieved judges have argued that the vetting process denies them the right of appeal, which is inherent, and insisted that the High Court has jurisdiction to hear appeals from decisions of tribunals appointed to consider the removal of persons from public office.
The constitution we gave ourselves say we must vet judges and magistrates, and that in vetting those judges and magistrates, nobody else can review or question that decision. So it is the Constitution. So the Constitution is valid, unless people are saying we are now questioning the validity of this Constitution. You cannot do that.
The matter now heads to the Court of Appeal to determine whether the High Court bench overshot its mandate. Francis Gachuri, Citizen Live at 9.